I'm David Freeman Engstrom. I'm a longtime law professor here at Stanford Law School, and as Roland mentioned, I'm also the co-director of the Deborah L. Rohde Center on the Legal Profession. I should for sure start by thanking Roland and the other conference organizers for allowing us to be here, for allowing us this opportunity to say something to you all right at the front end of another fabulous edition of FutureLaw. So I have the great privilege of teaching at the Silicon Valley Law School, Berkeley, and that means that I spend a lot of time in dialogue with the people who are shaping the 21st century legal system, and that includes students, lawyers, investors, and technologists, and I'm fielding lots of questions these days. My students are excited, but they're deeply uneasy. They're asking, is law school preparing me for the world I'm actually entering? Am I training for a profession or a workflow? Once I'm done clerking, will I join a firm, a platform, or a product team? Lawyers, meanwhile, are equal parts curious and alarmed. They're asking, how should I use AI and where are the lines that I just shouldn't cross? How do I train my junior lawyers? Am I building a professional practice here, or am I just getting dressed up for private equity? Investors, for their part, smell opportunity, and their questions are not subtle. How big can this market get? What are the regulatory choke points? How do I capture value without tripping over the bar? And how do I get those pesky lawyers to do what I want them to do? And then there's the technologists who've been trying to reinvent law for a while now, but think that maybe this time they really can. They're asking, just to continue the theme, how do I get those pesky lawyers and those investors to do what I want them to do? How do I capture market share? Or more to the point, how can I compete with the tech giants? Here's my personal favorite. When does John Haddock okay my acquisition by Harvey? Is John here yet? He's my former student. I thought I'd just give him a quick shout out. Excellent, thank you. All right, so here's what we think. We think that these questions warrant more than hot takes or product demos. They demand deep, rigorous, scholarly engagement. And there is no place better positioned to do that than Stanford Law School and the extraordinary research groups that it houses. And that, of course, includes, I'm biased, but the Deborah L. Rohde Center on the Legal Profession, which, of course, I co-direct. It includes CodeX. It includes the new Legal Innovation Through Frontier Technology Lab, a.k.a. the LIFT Lab. And it also includes Stanford Law School's new AI initiative. So Stanford Law School is launching a project. We're calling it the future of the law firm. And our ambition is not modest. We want to map what's changing, what's overhyped, what's genuinely new, and what it all means for lawyers, clients, and the legal system. And that's where our associate director at the Rohde Center, on stage with me here, Natalie, is going to tell you a bit more of what we're thinking. And it's going to begin, yes, with a map.
Thank you, David. Thank you, everyone, for being here. It is an absolute delight to be up on this stage. Happy Law Twitter spring break to those of you who celebrate. So, as David mentioned, we believe that the law firm and the future of the law firm sit at the very complex intersection of capital, technology, and talent. So we've developed this map along with many of you in the room. Thank you so much for your contributions to help us understand how these certain trends fit together and how they might reinforce one another. So we'll start with stop one, the client. Client expectations are rising rapidly, and they're reflecting the promise that AI-empowered firms can deliver routine legal services efficiently, faster, and theoretically cheaper. To survive the competitive pressures coming both from AI-forward firms and also in-house teams servicing more and more of their routine legal needs in-house, The law firm of today and the law firms of tomorrow must find new ways to create and to prove value. One way firms are doing this, and we'll move to step 2, actually 2 different steps on the tech side and the human side of the firm, which increasingly might be blurring together, is to automate firm workflows, of course. AI is facilitating the deeper extraction of lawyer knowledge and decision-making, making possible new practice tools. Something that LiftLab here at Stanford Law School, and you'll hear from Megan Ma later today, is at the cutting edge of thinking about. But are compensation and incentive structures reflecting this deeper extraction of individual attorney expertise? Should they be? An important and not surprising result at stop 3 is a shifting mix of human and AI talent that challenges the traditional law firm leverage model. The degree to which associate roles will be augmented versus automated is still playing out, but fewer associates may be needed per partner, and human associate leverage may be replaced by new forms of leverage enabled by AI. Law firms, and also law schools like this one, will need to figure out how to train young lawyers without entry-level tasks that teach legal and litigation judgment. New ways to deliver legal services and new forms of value creation are also taking external client-facing forms. We get to stop 4. Firms are creating new AI native products and services. And in doing so, these firms may be facilitating a more proactive approach to legal services delivery, moving away from the traditional reactive and downstream approach of intervention in client matters, and moving the core of what law firms are doing along a continuum from service to product. Some of these new products and services are built on law firm and client proprietary data. These integrations at stop 5 reduce friction in legal services delivery and also create sticky products and services. These tools may increase the value and the timeliness of service delivery, but potentially make it harder for clients to leave. And clients and customers don't like to feel stuck. Also, security, privacy, and data ownership issues will need to be ironed out. All of this has IP implications. Let's go to stop 6. Client-facing portals and self-service tools are wrapped in law firm branding, shifting client focus away from the individual attorneys and toward the law firm. As one person has put it, knocking on the door of the law firm now. But perhaps over time, this strips something from individual lawyers and dings satisfaction and professional identity. Relatedly, at stop 7, individual and collective lawyer knowledge, now translated into defensible IP, consolidates inside the law firm. Proprietary AI-enabled workflows and products developed in-house belong to the firm and stay with the firm once partners and associates leave. This protects the firm against partner defection, but again, what is the impact on the individual lawyers? At the same time that this enormous technical value is being created and consolidated in law firms, law firm ownership is evolving. The Rody Center over the last 7 years has been exploring and researching non-lawyer ownerships in several states in the US. And things recently have gotten really, really interesting. Coming to stop 8, we see managed services organizations, which are absorbing the business side of the law. This business side, these functions historically have included IP and firm technology. Yesterday's legal tech tools and subscriptions might not have been much to write home about. But today these bespoke tools are intertwined with the firm's production capacity. Lawyers may be shifting the most valuable layer of the business outside of the firm, and particularly to private equity. Given this reality, perhaps alternative business structures, ABSs, which allow for direct non-lawyer ownership of law firms alongside lawyers, are actually the solution to ensuring that productized services and automated workflows stay within the law firm. Maybe this reform that is so strongly opposed by many states is how we ensure that the future of legal services delivery stay in the firm. But just how far will this go when you combine AI with new finance models? One possibility, and this is a very good one if you follow PE trends in other industries, is MSO consolidation at stop 9. This has potentially enormous consequences for national law firm practice branding, competition, service delivery and pricing innovations, technology development and customer service, and of course, professional independence. Stop 10 is just a cousin to Stop 9. As enterprise legal tech platforms expand their offerings, an incredible amount of data on what lawyers do and how they do it is consolidated into these companies. All fine and good maybe while these firms are servicing lawyers and not competing against them, but maybe that possibility is just one ABS application away from reality. Or perhaps Google Law eclipses the law firm entirely, a fully platformized legal services marketplace. And with that, we'll turn back to David to tell you where we're going with this.
Thanks, Natalie. We hope that was interesting. That's kind of a beautiful mind-like diagram, but we think it's kind of a neat synthesis of what we see out there based on, now, I think hundreds of conversations we've had with folks about where all of this is going. So it's a lot, and obviously the legal system is on the cusp of massive change right now. But in some ways, it's actually quite simple, because we think we can distill all of this down to 3 core questions, and that's what we're going to build this initiative around. Question number 1, how will law firms create and deliver value? What becomes of bespoke judgment? And how will firms package expertise into those scalable products and platforms? And once again, that's where CodeX, LiftLab, so many other great components of Stanford Law School truly excel. Second question, who will benefit from and capitalize on these changes? Put more sharply, when the spoils are divided, who captures the upside? Lawyers, clients, technologists, or capital? Here's the third, and I personally think it's the most important of all, and this is kind of where I'm going to leave off with you all. Can law remain a fiduciary institution? It's a huge question. And many of the trends that Natalie just described are plainly going to chip away at lawyer independence through a mix of financial and operational pressure. If legal help becomes unbundled, automated, and platform-based, what becomes of professional loyalty, confidentiality, and independent judgment? And what happens to a self-regulating legal profession? And what happens to its role as a bulwark of rule of law, which it has played across key junctures in American history, but has never been more important than right now? Of course, Rome wasn't built in a day, and so we've already started to carve off tractable pieces of this as a way to answer these 3 really, really important distilled questions. We've currently got 3 lines of research underway. We're currently working on a set of papers on AI native law firms. We've got other research going on MSOs and what that looks like going into the future. And then a third line of inquiry continues our work on regulatory reform efforts. So that includes Arizona, I would say Utah, but they've downshifted quite a bit, maybe now Washington State, many other places, and what types of legal innovation is resulting when you relax those usual rules that say only lawyers can practice law and only lawyers can own and therefore capitalize law firms. And for all of these lines of inquiry, we're going to be asking for your participation and your help. We've already begun a set of convenings, including breakfast, seminars, and events here in Silicon Valley and starting next month in New York and Chicago. We'll also be holding a Future of the Professions conference this coming fall, co-hosted with Stanford Medical School, to think across professional contexts. And then we'll hold what will be an annual grand conference for the project starting next winter. We've already begun work on a book volume and hope to involve you titled The Future of the Law Firm. And we're going to start teaching a class this fall at Stanford and hope that some of you might be willing to come and visit and share your wisdom and your insight with our students. So I'm going to leave you with this. A map can tell you where things are, can tell you where things are headed, can tell you where you can go, but it doesn't tell you where you ought to go. And I think that's the challenge before all of us in this room, and if I may, for the future law community. We can build a legal system that is faster, cheaper, and more scalable. But to my mind, the more urgent question, the harder question, is whether we can build one that is still independent, still fiduciary, and still worthy of the public's trust. And that, we believe, is the future of the law firm. And our hope is that some of you agree and that we can work with you in the coming months and years to realize it. Thanks, everyone.